Exploring the profound realms of justice, the scope of judicial review unveils a tapestry where the judiciary, with discerning wisdom, weaves the trends of constitutional scrutiny, ensuring the delicate balance between governance and protection of individual rights. A very warm morning, respected dignitaries on this virtual dais, valued guests, most respected chairs, intellectuals, faculties, professors, and attendees from all over the globe. Greetings to one and all. We have all gathered here today to kickstart the 19th International Seminar on Judicial Review, Trends and Forecasts, put forward by Kerala Law Academy Law College in association with Center for Advanced Legal Studies and Research, CULSA, the research wing of Kerala Law Academy, which is conducive to unite nascent thoughts and ideals, along with IQAC KLA. This is Manupriya Chalan, along with my co-anchor, Gauri CV, the student moderators for this session, and we take the privilege to welcome each and everyone present here virtually. To welcome means to establish integrity. It is a moment of great privilege and honor for me to extend a hearty welcome to everyone present here today. The Kerala Law Academy Law College, established in the year 1966, is a center for legal studies, legal research, and pioneering law reforms. Kerala Law Academy is the first and was for many years the only private law institution in the whole state. Academy has never failed to prove its eminence and merit in various arenas in the field of legal education. To keep up with this legacy, the Kerala Law Academy, in association with Center for Advanced Legal Studies and Research, is organizing the 19th International Seminar. Before we begin this session, I take this opportunity to remember late Dr. N. Narayana Sir, former director, Kerala Law Academy, the torchbearer of our institution.
Thank you, Manupriya. Judicial review in India stands as a cornerstone of the Constitution, ensuring that both legislative and executive actions conform to the constitutional framework. This vital process, inspired by the US system, yet uniquely tailored to the Indian context, serves as a guardian of citizens' rights and a bulwark against arbitrary governance. In this exploration, we delve into the multifaceted nature of judicial review, tracing its historical origins, understanding its expansive scope, and appreciating its profound impact on India's legal landscape. This seminar aims to focus on the concept of judicial review. The scope of judicial review in India is quite broad, and it covers not only the laws passed by the legislature, but also the actions of the executive. The courts have the power to strike down any law that is in violation of the Constitution, and they can also issue writs like habeas corpus, mandamus, prohibition, certiorari, and quo warranto to protect the fundamental rights of the citizens. Here we have Dr. Dakshina Saraswati Ma'am, Assistant Professor, Kerala Law Academy Law College. Ma'am is also the General Secretary of Kerala Law Academy Moot Court Society. She has taken a PhD from the University of Kerala in the year 2017 on the topic International Law and Nuclear Power Plants, an Overview of Legal Framework. She has more than 16 paper publications to her name. Ma'am also presented papers in various national as well as international seminars. She has also organized more than 20 national and international seminars, workshops, and conferences. I am privileged to invite Dr. Dakshina Saraswati Ma'am to officially welcome our guests into this valedictory session. Ma'am, please.
Thank you, Gauri. Good morning to one and all. Honorable Mr. Justice Harni Krista, Dr. N.K. Jayakumar sir, Professor Dr. V. Sudesh sir, esteemed guests, treasured participants, and distinguished attendees. A very warm welcome to all those who have gathered here today. It's a great matter of pride and privilege to welcome the legal dignitaries who have gathered here to take part in the 19th International Seminar on the topic Judicial Review, Trends and Forecasts organized by Kerala Law Academy Law College. We are delighted to have each one of you joining us on this auspicious occasion. As we all know, judicial review is a crucial aspect of Indian Constitution as it allows the judiciary to act as a check on the legislative and executive branches of the government. It ensures that the government functions within the limits set by the Constitution and the rights of the citizens are protected. It's an essential mechanism to protect the Constitution and its principles and to ensure that they are upheld in the face of changing circumstances and challenges. Firstly, I would like to welcome our most distinguished guest of the day, Honorable Mr. Justice Dr. Harni Krista. We are indeed indebted to your Lordship for your valuable presence. In spite of Lordship's busy schedule, he readily accepted our invitation to be the chief guest of this inaugural session. Justice Harney Christa is presently the judge of Swiss Federal Supreme Court, Lausanne, Switzerland. From 2013 to 2017, he was deputy judge at the Supreme Court of the Canton of Bern. Then from 2017 to 2020, he served as a judge at the Supreme Court of Canton of Bern. In 2018, his lordship was a lecturer for civil procedure, University of Bern, and in 2020, Deputy Justice at the Swiss Federal Supreme Court. Since 2021, he is a justice at the Swiss Federal Supreme Court in Lausanne. His expertise lies in the field of corporate law, contract law, torts law, intellectual property law, and comparative law. On behalf of Kerala Law Academy, teachers, students, non-teaching members, and on my own behalf, I am deeply privileged to welcome Honorable Mr. Justice Harney Christa to this seminar. Hearty welcome, Lordship. Next, with immense privilege, I welcome Professor Dr. N.K. Jagumasa, former Vice Chancellor, Novals, Kochi. He has also served as Secretary, Kerala Legislative Assembly, Advisor Law to the Chief Minister of Kerala. Dr. Jagumasa's contribution as a professor, head and dean, Faculty of Law at University of Kerala have significantly shaped legal education and research. His absolute candor, sincerity, dedication, and commitment made him a living legend and a luminary in the educational, legal, and academic sphere. Sir is an exemplary Indian law educator, an eminent jurist, and also a recipient of Manath Krishnamenon Medal. Sir has always been a constant source of motivation and have paved ways for all of us to work hard and stay focused towards our goals. He is always there to extend a helping hand to all the activities of Kerala Law Academy. On behalf of Kerala Law Academy Law College and on my own behalf, I extend a warm welcome to you, sir. Now, I welcome Professor Dr. V. Sudhir to this session. He is an alumnus of Bangalore University. Sir has participated and presented papers in various international and national seminars and has been invited as a resource person by UGC HRDC and by other universities on a wide range of topics. Sir has several publications to his credit. He has served as the officiating Vice Chancellor of Bangalore University 2017-2018, and at present he is designated as Senior Professor and holds positions as Principal, Chairman and Dean, Faculty of Law in the University of Law College and Department of Studies in Law, Bangalore University. On behalf of Kerala Law Academy, teachers, students, non-teaching members, and on my own behalf, I heartily welcome you, sir.
Thank you.
Our journey would have remained incomplete with the wholehearted support of Advocate Nagaraj Narayan sir, Director, Kerala Law Academy Law College, and Advocate High Court of Kerala and Member Bar Council of Kerala. Sir has consistently championed every endeavor in the college, inspiring us to strive for excellence. We owe you a debt of gratitude, sir, for being our constant source of support and for instilling in us the courage to excel. Hearty welcome, sir, to this seminar. A special mention and profound thanks goes to Professor Anil Kumar Kesa, Director, Administration, Students and Faculty Affairs, the visionary behind all the events conducted by Kerala Law Academy. Your enduring support and dedication are the driving forces behind our success, sir. Your thoughts have enlightened our minds and have shown us a new path. We are truly grateful. I wholeheartedly welcome you, sir, to this session. In our journey, we have found unwavering support in Professor Harindran K., who serves as a guiding light in the role of Principal Kerala Law Academy. His commitment and devotion to our institution and relentless efforts is truly praiseworthy. Hearty welcome, sir, to this session. Furthermore, I would like to express my heartfelt welcome to Professor Anil Kumar Ji, sir, the Vice Principal of Kerala Law Academy Law College, whose wisdom and guidance have been instrumental in bringing this event to fulfillment. His dedication to fostering knowledge and excellence within our institution is truly inspiring. Hearty welcome, sir, to this session. Additionally, I extend my deep welcome to Professor Dr. Ajita Nair L. Senior Faculty, Kerala Law Academy Law College, whose consistent encouragement has been instrumental in our achievements. Hearty welcome, ma'am. Now, I would like to extend a warm welcome to our faculty conveners of this seminar, Advocate Radhika R.P., Advocate Vidya V.V., Advocate Naya Swati Bala Saraswati. Your continuous efforts play a very important role in making this event a reality. Last but not the least, I would also like to extend a warm welcome to all the participants, faculty members, student conveners of this seminar, non-teaching staff, IT team, and all those who are present here. I conclude by extending my heartfelt welcome to everyone attending this session. Thank you.
Thank you so much, ma'am, for your warm welcome. I also take this opportunity to graciously welcome you two into the session, ma'am. We are indeed honored to have Justice Sudnik Kustev, Judge, Swiss Federal Supreme Court, Lausanne, Switzerland. He holds a PhD from both the universities of Bern and Bologna, Italy. He also writes and publishes widely on Swiss, European, and comparative law and related topics. Before becoming justice at the Swiss Federal Supreme Court in Lausanne in the year 2021, his lordship has been a deputy justice at Swiss Federal Supreme Court and judge at Supreme Court of Canton of Bern. I am deeply privileged to invite Honorable Mr. Justice Sudnik Kustev for the inaugural address. Lordship, please.
Thank you very much. I'm very dear and distinguished and respected professors, respected guests. I'm very honored and very proud to be able to speak here today. And although it's a bit late, I wish you a happy belated Indian Republican Day. I noticed yesterday that you had a holiday yesterday, and it seems an important constitutional holiday, and which it comes in the topic of today. I have a question. Do you have my slides? My slides to project?
Yes, sir, yes.
I prepared some slides.
Okay.
I will tell you when to switch. Yes, thank you very much. I would like to have some remarks about judicial review in Switzerland. As was said before, the Indian constitution is, or the Indian legal system seems to be shaped as a federal state on the model of the United States Constitution. The same is true for Switzerland, although Switzerland is just like a micro state compared to India. But also Switzerland is composed of federal states, the so-called cantons. I was sitting as a judge of the Supreme Court of the Canton of Bern, which is one of these small entities. 26 of these small entities are composing the Swiss Confederation. And yes, exactly. Here, the Federal Supreme Court, this is Article 188 of the Federal Constitution of the Swiss Confederation, and the Swiss Federal Supreme Court is the supreme judicial authority of the Confederation. It has, when you can go to the next slide, although not a very broad purpose when it comes to judicial review. As you can see in Article 189, the jurisdiction of the Federal Supreme Court is laid down. The Swiss Federal Supreme Court hears disputes concerning violations of federal law, international law, intercantonal law, and so on. And what is highlighted here is paragraph 4, acts of the Federal Assembly. The Federal Assembly is the parliament, the federal parliament, or the Federal Council, which is the executive branch, may not be challenged in the Federal Supreme Court. Some exceptions are provided for by the law, but the principle is that acts of the Federal Assembly or the Federal Council may not be challenged. This is because little Switzerland does evaluate democracy as more important than rule of law in a certain sense. And it also has another aspect. Federal acts of the Federal Assembly can be controlled by popular referendum. So in a certain sense, popular referendum assumes the function of judicial review. But we can perhaps go on with the slide. It is also reflected in Article 190 that the Federal Supreme Court is obliged to apply the federal acts and international law. And here you can see, because it is obliged to apply also international law, there is a judicial review of federal acts, not with regard to the Constitution, but with regard to international law. So international law supersedes federal acts. Perhaps you can go on with the next slide. The cantons, they also have judicial authorities, and also the judicial authorities of the cantons are obliged to follow the same principles. And now comes the judicial review. Perhaps you can go to the next slide. Here you can see that's the Federal Supreme Court Act. The Federal Supreme Court judges appeals against decisions in matters of public law and against cantonal laws. So here you have a direct judicial review, but not with regard to federal acts, but with regard to cantonal. This means cantonal acts. Cantonal means acts of the federal states, of these little statelets that compose the Swiss Confederation. There you have a full judicial review. You can directly appeal against these acts. Grounds for appeal, you can go forward to the next slide. Grounds for appeal are federal law including constitutional law and international law. So there is a review, a judicial review, according to the standards of federal constitutional law and, of course, international law. Perhaps you can go to the next slide. We distinguish between incidental and direct challenge of legislation. An incidental challenge of legislation takes place when there is a challenge, when an individual case is brought before a court or before an administrative body, and when the parties allege that within these individual case, the applicable law is not in accordance with constitutional law or international law. A court will then proceed to conduct a two-tier review. First, it will examine whether the normative basis for the legislation was lawful. This is what we call the incidental legal review. And second, if this test is met, the court further examines whether the law was applied correctly. However, as I said, Article 190 of the Constitution expressly prevents judicial review of federal legislation, requiring the court to apply federal laws even where the court finds the law to be unconstitutional. That is, again, as I said, because of the principle of democracy, which is considered as more important than rule of law on the level of the federal state. Then the next slide, we have direct challenge of legislation. A direct challenge to legislation is possible against cantonal laws and ordinances. The cases that challenge cantonal laws are typically decided directly by the Swiss Federal Supreme Court, because normally there is no legal remedy at the cantonal level. And then the Swiss Federal Supreme Court may really quash cantonal law, thus rendering them fully or partially invalid. And even if the court does not invalidate cantonal legislation, it may give important guidelines for the cantonal authorities on how to apply the law to ensure the constitutional boundaries are respected. This happened, for example, recently concerning police legislation enacted by the Canton of Zurich. Perhaps to the last slide. What is important is legal standing. Legal standing for challenging cantonal legislation is very broad. It's far broader than in cases concerning administrative decisions. A person may challenge, an individual may challenge legislation if she or he can claim that there is a possibility, even a remote one, that she or he will be affected by the act. So a single citizen has standing when it comes to the direct challenge of cantonal legislation. an appeal against legislation itself does not preclude an individual from later invoking a legal remedy against an individual administrative decision. And in this respect, a cantonal law may be challenged twice. First, in abstract terms regarding how the act could be applied, and later then regarding how the act was applied in practice. So there can be a combination of direct and indirect judicial review. So thank you very much for your attentions. These are my short inputs about judicial review in Switzerland, which is not a full-fledged judicial review like you have it in India or in the United States. Thank you very much.
Thank you so much, sir, for providing us the opportunity to imbibe your words of wisdom. Today, we have the esteemed presence of Professor Dr. N.K. Jayakumar, sir, former Vice Chancellor, Noals Kochi. His academic experience as a renowned faculty of law spans across various universities, including University of Kerala, Kannu University, and Dr. Ambedkar Law University, Chennai. Dr. Jayakumar has been selected as a National Associate by the University Grants Commission in 1979. He has been Visiting Fellow, Australian National University, Canberra in 1987, and Visiting Professor, Vienna University, Austria in 1998. I take the privilege to invite Professor Dr. N.K. Jayakumar, sir, for the presidential address. Sir, please.
Can you hear me now?
Yes, sir.
Yes, sir, you are audible.
Thank you. Honorable Mr. Justice Arnie Christopher, which is Federal Supreme Court Judge. Professor Sudesh, Senior Professor, Bangalore University. The organizers of the seminar, Dr. Dakshina, Radhika P. Student moderators, Anupriya, Gauri, faculty, students, researchers, and others associated with the Kerala Law Academy. Friends, I am really happy to be associated with this international seminar on judicial review. It's a refreshing change to listen to the words of Justice Arnie Christopher. Because often in our discussion, we invite professors from America, Australia, United States, or some other common law countries. In fact, in this small but very impressive presentation, Justice Arnie Christopher thrown light on the different aspects of judicial review in Switzerland. I was particularly impressed by one feature of the Swiss system, which was presented before us by Justice Arnie. You must have noticed that Justice Arnie has underlined the expression, we consider democracy as more important than rule of law. This statement perhaps shatters the very foundation of judicial. Because judicial review is based on the principle of rule of law, and our attempt in India is to reconcile judicial review with rule of law. To what extent we have succeeded and to what extent we may be able to succeed in that endeavor is a matter which we have to prove. I'm sure that seminars of this nature with international dimensions and scholars from different parts of India meeting together and discussing. This is a very relevant and meaningful exercise. So I congratulate the organizers of this seminar for selecting this very important topic, which never loses its freshness. In fact, judicial review is one of the most widely debated and discussed topics in public law. Discussions never end. New dimensions are added to the debate on judicial. There are those who support very strongly the idea of judicial persons who are vehemently opposed to the idea of judicial review, especially judicial review of legislation. As the Swiss system seems to hint, how can we have a system of strong judicial review when they have also accepted democracy as the cornerstone, the foundational idea which sustains our system? Are they not irreconcilable? Democracy is based on the concept that we elect our representatives to make laws which are necessary for us. Because we have the basic law, the Constitution of India. And the lawmaking power of our representatives in Parliament or in state legislative assemblies. It is subject to the Constitution. It has to remain within the four corners of the Constitution. But who will decide this question and how? This is the whole idea of discussion. Years back, decades back, somebody asked a judge of the American Supreme Court about the Constitution of the United States. This judge, known as a very arrogant person, he said, yes, we are under the Constitution. But the Constitution is what we say it is. We for judges. No doubt about that. So the Constitution is not what it appears to be. Constitutional provisions are not direct. Constitutional provisions are expressed in language which is not certain. There's no certainty of When the Constitution of India says no person shall be deprived of his life or personal liberty, except according to procedure established by law. It's a very simple sentence. But look at the dimensions unraveled by judicial interpretation. By interpreting this very simple provision. What does life mean? What is procedure established by law? Should that procedure be a reasonable procedure, fair procedure? That requirement circumscribed by what is stated in Article 19? So many questions arise. So many answers have emerged. So this single article, judicial interpretation of this single article, Article 21 of the Constitution, very clearly reveals the scope of judicial interpretation, role of judicial creativity, role of judicial dynamism or judicial activism, whatever you may call it. This can have good as well as bad consequences. So again, draw your attention to the observation with which I began my presentation. That how do we reconcile democracy with judicial? So oppose the idea of judicial review always base their argument on democracy. Judicial review is incompatible with democracy. That is their argument. And countries where strong judicial review exists, like the United States of America or India, this question is very much pertinent. And I'm sure that the deliberations which we are going to have in this seminar will be able to throw a light on various dimensions of this issue. Of course, judicial review doesn't mean judicial review of legislation alone, but that is really the more important aspect. Judicial review of administrative action is also an equal. Also a question of equal importance. But there, the controversies seem to be more or less secular. The principle that the executive must remain within the boundaries of law. And their powers are always limited. And whenever they exceed their powers, must be clearly established and corrective steps have to be taken. Ultra-vires actions can never get the stamp of validity. They are nullified. But even in judicial review administrative action, the attitude, the approach, the way in which judiciary handles their powers of judicial review, is a very crucial aspect. Recently, people have started about red light theory of judicial review and green light theory of judicial review as far as judicial review of administrative action is concerned. Red light theory conceives the role of the judiciary as a kind of policeman. One judge of our Supreme Court has even used the phrase our task is policing the corridors of power. You are speaking with reference to administrative power. And when you consider yourself as a policeman, keeping the administration within the boundaries of law, your interpretation, your decisions, your perspective will be very different. Or it is also possible to look at the powers of the administration in a different light. Unless we have an executive which is very much committed to implementing the policies of the government, enforcing the laws that have been enacted by the legislature. Suppose at each and every stage, judiciary interferes, the judiciary lays down its own policy as well. Where will it end? Do we achieve the socio-economic goals that we have laid down? How do we achieve the ideas of justice, social, economic, and political envisaged by our constitution makers? If you do not concede a certain area of freedom of action to our executive to function. There are many areas, typically conspicuous areas of judicial review of administrative action, where the judiciary itself have taken over the power of laying down rules. Just take the instance of admission to institutions of higher education. Cases like Mohini Jail by foundation. You find that it is not our government, executive branch of the government, actually lay down policy and implement it. But the Supreme Court of India, which has really laid down the norms of admission, especially to professional college, it's an unending series of controversies. Very idea of NEET, national eligibility test, which is vehemently opposed by states like Tamil Nadu. So the question is, do judges have that kind of mandate, that kind of expertise as educational policy makers or as financial policy makers? Is it within their domain to make far-reaching pronouncements of far-reaching consequences, which alters, substantially alters the law of the land, lays down new law, new rules, new policies? So I would consider judicial review of administrative action also as a very competent, very significant area, which deserves our keen attention. As far as judicial review of administrative action is concerned, maybe there are more precise guidelines and stronger constitutional foundations. People who have compared the American and Indian systems of judicial legislation, they have come out with a finding that the American Constitution judicial review is not specifically, categorically laid down. Whereas, in the case of India, this is constitutionally accepted. I would agree with that to a certain extent, but if you read the debates in the Constituent Assembly, I would like to draw your attention to the words of Jawaharlal Nehru, one of the important architects of the Constitution. When judicial review was, idea of judicial review was introduced and debated in the Constituent Assembly, what did Jawaharlal Nehru said? Yes, we need a judicial organ with a constitutional power of judicial. But we do not want to establish a judiciary which can override the will of the people expressed through legislation. Technical matters, matters of detail. If we go wrong, they can correct us. But they cannot substitute their own policy or ideological vision on the lawmakers. Subsequently, just find out what has happened. Especially judicial interpretation of the right to property. Paying compensation for property acquired by government. The long line of legal battles, which ultimately resulted in the deletion of right to property from Part 3 of the Constitution. Really made a political role, no doubt about that. Today, the question about the ideological role of the Supreme Court and where they will stand when ideological conflicts arise. Basic constitutional values like secularism, socialism, etc. are under threat, under challenge. So I would say that judicial review of legislation is a very important, very powerful, very potent weapon in the hands of the Commission. How do they use it? Unfortunately, fortunately, judges are not free from bias. I don't mean personal bias. Deciding one particular case in favor of a particular individual, that not that kind of bias. But bias which is ideology. A great judge like Justice Cardoso of the United States, while delivering some lectures in the Yale University in America, he frankly admitted that judges are not free from the prejudices, predilections, different types of bias which affect decision making by an individual, ordinary individual. Judges are also subject to that kind of influences. And when we have such people empowered with the capacity to make authoritative pronouncements on basic issues, what will be the consequence? What kind of risk we are taking? Now we have completed 50 years of the basic structure of doctrine, enunciated by the Supreme Court in Keshavananda Bharati. Have we ever been able to make a proper assessment of the way in which that doctrine came to be introduced? Its impact, not only on constitutional development, but we as a nation in our journey to social justice. Whether basic structure doctrine has accelerated our progress or retarded our progress. There are many such questions which arise. And maybe there is no other judiciary in the whole world which is so powerful as the Indian Supreme. Americans may say that their Supreme Court is very powerful. Yes, it is, but compared to Indian Supreme Court, the American Supreme Court, I would say, is based on very, very weak constitutional foundations. Whereas Indian Supreme Court stands on very firm constitutional foundations and they are asserting power. Review is not merely confined to legislation and administrative action, but judicial review in India is spreading its wings and embracing even amendments to the Constitution, basic law. This is perhaps we must examine. Young jurors who are presenting papers and deliberating these issues must examine whether the Indian higher judiciary has gone beyond what our constitution makers have envisaged. Whether our constitution makers have conceded this kind of omnipotence to the judicial organs, especially Supreme Court. This also makes the appointment of judges a very important, very crucial issue. Who makes the appointment and how the appointments are made. Since that itself is a vast area, I am not opening it up for discussion now. But the kind of judges we have, the kind of vision that these judges have, and the way in which they lay down law regarding important constitutional matters. This is very crucial for our very survival as a democracy, as a state which is committed to social justice. So probably deviating a little bit from technical legal issues of judicial rule. I am optimistic that some of you will go the social dimension of judicial issue, political dimensions. Today I am very happy to be on this platform, with this virtual platform. I find Professor Sudesh, and when I see him, my memories go back to and my association with this institution, the University Law College, Bangalore, where I had a lot of intimate friends, starting from Potino. I hope we will have an occasion to meet, not virtually, but physically. So I wish the deliberations all success and hope that you will have a very active, academically fruitful time in this 19th International Seminar. Thank you for giving me an opportunity to present my ideas in a very disorganized form. Excuse me for not putting my thoughts in a systematic manner. We will continue this discussion. No discussion ever ends. Academic discussions are continuing discussions. Thanking you again and wishing you all the best.
Thank you so much, sir, for your words of wisdom. Now we have Professor Dr. V. Sudhir, sir, Principal, Chairman and Dean, Faculty of Law, University Law College and Department of Studies in Law, Bangalore University, to deliver a special address for the session. He is a senior faculty in the arena of labor law and has also served in various capacities such as former Register for Evaluation and Register, Karnataka State Law University, Hubali. Sir has also served as a member of Syndicate, Senate, and Academic Council of different universities, a member of BOEs and BOS, and Faculty of Law, and chairperson of multiple local inquiry committees to inspect academic standards of the institutions. He has multiple publications and awards to his credits and has also guided a number of students at PhD and PG programs. I am deeply honored to invite Professor Dr. V. Sudhir, sir, for the special address. Sir, please.
Thank you. Let me clarify the introduction that was given by Manupriya. The first few lines of my introduction were not mine. It was my other colleague Suresh V. Nadgowda, and I was never a registrar evaluation. I was an in-charge vice chancellor, and I am now principal, chairman, and dean faculty of law of University Law College, Bangalore University. Okay.
So my
Thank you.
apologies.
No issues. No issues.
My apologies.
At the outset, let me thank Justice Harni Christoph, Judge, Swiss Federal Supreme Court, Switzerland, for presenting the Western view of judicial review, which, as Professor Dr. N.K. Jayakumar said, is contrastingly different from what we preach and practice in India. The president of today's webinar, Professor Dr. N.K. Jayakumar, a very revered professor, a long-time friend of University Law College. His association with our college, especially with my guru, my teacher, the late Professor Bicutino, is legendary. I thank you, sir, for remembering my teacher and the college. And your views today has in fact presented a very comprehensive yet very scattered view on judicial review. I fully agree that in a presidential address or in an inaugural address, we cannot present a very clear picture of judicial review, but the topic itself is like that. Let me also congratulate the organizers of this webinar for making a very appropriate title to this webinar: Trends and Forecast, Judicial Review Trends and Forecast, and very aptly signified because today begins the 75th year of our acceptance of our constitution, the Republic Day. Yesterday we celebrated. So in this 75 years, it is right time that we examine the most talked about concept or topic, judicial review. Let me also begin my presentation with this quote from H.L.A. Hart, jurist. He says, I quote, "The Constitution works as the touchstone for all other laws. Perhaps judicial review in India has been working with this mandate that the Constitution works as a touchstone for all other laws." So in India, Indian judicial review begins with the rule of constitutional justice, rule of law, rule of constitutional justice. And later on, we find the trend transforming it itself into identifying social justice and protection of fundamental rights, especially under Article 21 of the Constitution of India. Insofar as speaking about the trends, I find that post-constitutional era, the goal of a new and a vibrant India was the sole aim. Achieving a new and vibrant India was the sole aim of the legislature, and thereby enacting legislation, enacting laws which fulfilled the constitutional aspirations. With the passage of time, disappointment by the citizens, failure of the administration probably, we find that the judiciary to a large extent has controlled, has rather taken charge of fulfilling the preambular promise. Because remember, students, we said we have a preamble, we the people of India. So we the people of India, including the judiciary as an institution, has to ensure, has to fulfill the promise of justice, liberty, equality, fraternity. And all of us will agree as students of law that to a large extent, these things are achieved or in the process by the judiciary exercising its review power. And nothing wrong in it, because ultimately Articles 13, 32, 131, 143, 136 also, 226, 240, all these articles give power to the Supreme Court, to the judiciary, to exercise its power to fulfill the preambular promise. And let us not forget the doyens of Indian judiciary who had their mark on judicial review, Justice Krishna Iyer, Justice P.N. Bhagavati, and many others, the pioneers of judicial review in India. Well, friends, we must at the outside, in order to appreciate judicial review, in order to identify its strength, we need to tell ourselves that the progress of the society is dependent upon proper application of law to its need. That is the essence of the working of the judicial review. Well, many jurist critics have, in a nutshell, tried to identify the two trends in judicial review. One, they say, is the protecting the constitutional ethics, the trend towards protecting the constitutional ethics, or what we generally say as legal constitutionalism. Now, legal constitutionalism suggests that the lawmakers, legislators, and the citizens voting them into power may not necessarily embrace the value of constitutional democracy. It's actually a deal. As Richard Posner says, it's an economic deal between the voters and the voted, the electors, the elected. It's a deal that we vote for you and you give us so much of benefit. So that may not at all times include the constitutional value. So if you have that view of legal constitutionalism, we have to submit that it is the legislature which is the supreme authority, which has the power to make any kind of law to protect the interests of the citizens. Now, the problem here is that since the legislature may not at all times embrace all constitutional values, it becomes the duty of the judges, the judiciary, the higher judiciary, to protect the same. Through this, the judges act as a key check or restraint on the power of the legislature, evaluating whether legislation satisfy core constitutional values or not. Now, such values extend not only to protecting fundamental rights, but also an evaluation of competing interests considered by the legislature, such as public order. Now, there are so many examples. We started education on the Bharti case. In recent times, for example, the constitution composition of election commission, the judgment of the Supreme Court on Aadhaar, Article 370, etc., etc. So there is always a clash between the legislative interest of passing the law and the judicial power of checking whether these laws are in tandem with the constitutional values. However, notably, such a check or restraint exercised by the Supreme Court revolves around evaluating the correctness of the legislation through judicial scrutiny. Correctness of the legislature through judicial scrutiny that does not extend to the judiciary taking up the role of the legislature in prescribing legislations. Because doing otherwise threatens a compromise upon the political constitutionalism of the legislature. So, in a sense, protecting the constitutional ethics or protecting the legal constitutionalism gives power to the judiciary to only check whether the law enacted by the legislature meets the constitutional vision, constitutional values or not. Beyond that, it is not supposed to act. Now, going by the other view, which we may classify as protecting the political interest of the legislature or political interest and political constitutional interest of the legislature. In short, we may call this as political constitutionalism. Now, here also, the legislature is equally, if not even more legitimate and capable than the judiciary at resolving both fundamental and substantive disagreements. Instead of ensuring judicial oversight over the legislature to enhance the democratic process, it in turn emphasizes upon improving the electoral and parliamentary system. Here, the sole intention of the legislature is to improve the electoral and parliamentary systems. This would be through ensuring proper proportional representation and parliament scrutiny. Moreover, it focuses upon the importance of political compromises through meaningful deliberation and debate between political parties, competing for the support of diverse interest groups who have in turn a cross-cutting interest. Take the case of abrogation of Article 370 and its judgment on the judgment on that by the Supreme Court of India. Fine. By focusing on the decision-making process and not solely its outcome, by ensuring transparency in participation and balancing institutions, political constitutionalism locates the constitutionality of legislation within the political and the legal system. And that is the function of judicial review as per political constitutionalism. Through this, we can observe that while legal constitutionalism conceptualizes the judicial policing of rights and scrutiny as the key to constitutional culture, political constitutionalism and views. Now, the problem here is that the political constitutionalism views democratic participation as central to the theme of protect the constitutional values. So whenever a legislature enacts a law in the interest of the citizens who voted them, here the political constitutionalism says that that is the core interest which the constitution has to protect. Now, what is the solution? Professor Jaikumar said that sometimes the judiciary through judicial review is taking away the function of the legislature. And of course, I think many of us will agree, the National Judicial Appointment Law is a classic example of how through judicial review, the court took away the function of the legislature. And many criticize that judiciary votes for itself. Judiciary is not an elected body. So what is the solution? The balance is the solution. The balance between matching legal constitutionalism and political constitutionalism is the solution. So in India, we may say that there are competing interests between protecting the interest of the legislature who in turn protect the interest of the citizen. There is the function of the judiciary to test the correctness of the law in the constitutional scheme of things. Now, who is the authority to interpret the constitutional values? By and large, people will say it is judiciary. So therefore, what I have to submit is that the judicial review in course of time has to balance these two interests, protecting the interest of the legislature because it is the supreme authority as far as making the law. Judiciary, the guardian of the fundamental rights. Judiciary, protecting the interest of the downtrodden. Judiciary, the torchbearer of social justice. Now, the forecast. The forecast has to be seen from the political happenings around this country. Today, we are questioning the impartiality of the governors in India, several states in India, several executive heads having conflict with the interests of the governor, governors themselves being very political, though they have to be apolitical. In this background, consider the role of the speaker in democracy. Consider the role of the speaker in disqualifying members. Consider the role of speaker in allowing members for discussion. So friends, the political situation in this country will tell what would be the future of the judicial review, the forecast. My personal submission at the end of my inaugural address is that, though of course I did not get time, we don't have the time to elaborate on each and every case, but let me tell you, we shall not hero worship, as Dr. Ambedkar said. We shall not hero worship any institution, because Dr. Ambedkar himself said the moment individuals are hero worshipped, the institution also fails. An individual who holds that institution also fails. Because Dr. Ambedkar's preference for a parliamentary form of government was in the belief that an active parliament that broadly mirrors differences of interest, identities in a society can ensure continuous accountability through oversight of the executive branch. By focusing on the political, an active parliament is in line with the idea of constitutionalism, which require the citizens to be vigilant against unbridled populism by acting as a check on the culture of hero worship. Remember Dr. B.R. Ambedkar. So, in the light of the charismatic personalities that we have around as political leaders, if we, the enlightened citizens, do not check the overarching power exercised by these personalities when they occupy institutions, probably we will be failing in making them accountable to citizens. Similarly, also applies to the judiciary. We, the enlightened citizens, we the lawyers, teachers, students, the general academia, unless we bring out the nuances of judicial review within the constitutional scheme of things, we will also make the judiciary hero and hero worshipping private. Well, supreme but not infallible is the word which I use, the sentence which I use to conclude my sessions today. Thank you everybody there for giving me a wonderful opportunity to very briefly express my thoughts on judicial trends and forecasts. Thank you.
Thank you so much, sir, for your deep insights on this multifaceted topic. Feeling gratitude and not expressing it is like wrapping a present and not giving it. Now, it's my pleasure to invite Advocate Radhika R.P. Ma'am, Assistant Professor, Kerala Law Academy Law College, for the vote of thanks. Ma'am, please.
Thank you, Gauri. Esteemed and respectful morning greetings to all dignitaries. It is an infinite privilege for me to put an vote of thanks in this inaugural section of the 19th International Seminar on the topic titled Judicial Review, Trends and Forecasts, organized by Kerala Academy Law College in association with CULSER and IQAC KLA. The primary concern to extend my sincere gratitude is to the prime mover of this prestigious institution, the most illuminated personality, Dr. N. Narayanan Nair sir, Kerala Law Academy, who always remains as an inspiration for us in conducting these events. The preeminent person for this thoughtful gathering, today's remarkable distinguished chief guest of the inaugural session, Honorable Mr. Justice Dr. Vernick Christoph, who amidst his busy schedule graced us on this occasion and enlightened us with his treasured and praised words. On behalf of Kerala Academy Law College and my own behalf, I extend my deepest gratitude to you, Lordship. I am respectfully denoting thankful notes to the illustrious jurist Professor Dr. N.K. Jayakumar sir, former Vice Chancellor UIS Kochi, and also occupied various firm positions in legal arena for making us enlightened with the better words. On behalf of Kerala Academy Law College and my own behalf, I extend my sincere gratitude to you, sir. With an esteemed thought, I would like to indicate acknowledgement notes to Professor Dr. V. Switzer, Law College, Bangalore University, for his august presence in this session and for sharing valuable insights, sincerely expressing thanks to you, sir.
Thank you.
The prompt pioneer of this renowned academic institution, the well insightful and conversant personality, highly valued Advocate Nagas Nayan sir, Director, Kerala Academy Law College, member Bar Council of Kerala. We are indebted to you, sir, for being our sanctum for strength and for giving us firmness with a sincere mind. I am expressing gratitude to you, sir. The well-informed and appraised person in this institution whose systematic thoughts is spreading in every academic activities. Esteemed Professor K. Alkumar sir, Director, Administration, Students and Faculty Affairs, Kerala Academy Law College. He is a brilliant academician with years of experience in the field of legal education. I express my genuine out of thanks to you, sir, for being a robust upholder of us. Professor Harindran K., our principal, is always a source of inspiration to all the academic activities in this college. He always extends his support and guidance to all achievements and livings organized by this college. I extend my sincere thanks to Sri Harindran sir from the depths of my heart. With an earnest and devout mind, I would like to express my inimitable gratitude to Professor G. Alkumar sir, Vice Principal, KLA, and Professor Dr. Ajita Nair Elma, Senior Faculty, KLA, for their roles and attendance support throughout the event. We have also been credentialed enough to be backed by a team of devotees and so as organizing committee composed of Advocate Vidya Ma'am, Assistant Professor Kerala Academy, and Advocate Nair Saraswati Balasaraswati Ma'am, Mood Trainer Kerala Academy. I sincerely thank them for their steady presence in this session. I am mentoring gratitudes to Dr. Dakshina Saraswati Ma'am, Assistant Professor Kerala Academy, one of the faculty conveners of this event, who also delivered the welcome address on this occasion. Thank you, ma'am. With sincere mind, expressing my immense sense of obligation to our ITP, office staff, technical and administrative staff, student conveners, anchoring team for their tireless effort for the successful of this event. After all, I would like to extend a recognition to all students and other attendees for your kind cooperation and patience throughout the session. Thank you everyone.
Thank you so much, ma'am, for expressing your heartfelt gratitude for this inaugural session. With that, we have come to an end of our inaugural session. On behalf of our institution, I would like to thank all the dignitaries for joining us and enlightening us with their most valuable words. I use this opportunity to express my most sincere gratitude towards Advocate Nagaraj Narayan sir, Director, Kerala Law Academy, and Professor Anil Kumar K sir, Director, Administration, Students and Faculty Affairs, Kerala Law Academy, for their inevitable support throughout this event. I would also like to thank all the other faculty conveners for their unending support. I'm thankful to our student conveners for their tireless efforts for the success of this event. Last but definitely not the least, I also extend my heartfelt thanks to all of you for your kind cooperation and patience. Thank you, everyone. Have a great day ahead. This is Manipriya Chandan, along with my co-anchor, Gauri CV, signing off. Thank you.
Thank you, sir. Thank you, everybody.